DIY divorce is a legal version of hold my beer. My name is Josh Floyd.
And I'm Christina Jimenez.
We're both board certified family law attorneys here at Jimenez Floyd Family Law Firm. And here on the consultation, we're going to tell you why hold my beer is a bad idea.
So what we're talking about today are these DIY forms that you can now...
That means do it yourself.
Do it yourself form. Thank you, Floyd. That you can find online. And normally when we see them, it's unfortunately after the fact, right? So a party has done a DIY divorce. They are now having issues because the other side is not complying. And so they bring these forms to us and they say, hey, in this form, it says X, Y, and Z. They're not doing it. I need your help. I would say probably 80% of the time when I start looking at these forms, I can normally close my eyes the way that I just did, and I shake my head. And a lot of times will call Floyd and say, hey, I'm in this consultation. This is what they did. And sometimes it is there's nothing that we can do to fix this. It's, been too long. It's beyond repair. The judgment's final. And those are really, really sad situations when that happens. And so, the only time that I would ever say it's okay to do a DIY divorce if there is absolutely zero property, like nothing that you guys have ever purchased during the marriage or that you presently own, and if there's no children involved. I think that rarely happens, but if that's the case, then maybe you'll probably potentially be okay filling out the forms because there's nothing to fight over, nothing to divide. And I understand why people will sometimes want to do a DIY divorce, right? One of the biggest hurdles to overcome when starting the divorce process is the cost associated with it. And a lot of people can't afford to hire an attorney. And so they try to figure it out on their own and they go to these forms. So I understand that is definitely a factor. The other reason sometimes people do
it's faster. They think it'll be faster. On your property, if you don't have property, that's something that rarely happens, right? I mean, you have to be married like 6 months, right? Because anything that you make is community property. Any money you have in accounts, just things are acquired naturally over the course of time that are community property. Even if it's solely in your name, I have that conversation with people all the time. We don't have any property. We have a vehicle, yeah, but it's in my name, still property, right?
Right.
So it's very rare when you don't have any property. But yeah, so speed is one of the factors that they look at. Because they think they can do it faster than we can. Mm-hmm. I promise you, if it's amicable, we can do it a lot faster, mm-hmm. right? It's just as easy for us to do it correctly than it is for you to do it incorrectly.
Well, and then that's one of the things that they'll say all the time is like, well, I don't want to hire a lawyer because I don't want them to get mad, right? I want it to be an amicable divorce. And if I hire you, then everything's going to blow up. And I understand the fear, right? For sure, I understand it. But if you go through it solely because you don't want to fight about something now, it will likely result in you guys fighting over something in the future. And so you got to be careful with it. Here's the thing. If you find yourself in this DIY divorce situation and you go through and you fill out the paperwork and then you get the judge to sign it, then it's a final judgment. And sometimes there are no takebacks, right? And so our best recommendation is don't do it. Please don't do it. Even if you have to find an attorney who hasn't been practicing as long as we have, who's not board certified, but they're more, cost effective. At least you have some guidance on how to get through this process, and it will be much better than doing it on your own. And I tell people in consultations all the time, like, I consider myself to be a pretty intelligent person. I know Floyd disagrees. I didn't know to leg over.
Low bar you out there.
but if I have a plumbing issue or if I have, some sort of repair that I have to do at my house, I don't do it.
Water hose taken off.
I need a water hose taken off. I don't do it because the probability of me actually screwing it up is extremely high. And it's not that I'm not smart. So it's not that you're not smart. It's not that you're not capable. It's just, there's a reason why we have to go to law school for a really long time. There's a reason why it's called the practice of law, because we have done this thousands and thousands of times and we learn, how to get through these processes. You just don't know what you don't know, right? And so even though I'm really smart, you're not going to see me doing any plumbing, right? Just like you probably shouldn't be doing your own divorce.
And judges and their staff and the clerks, they can't help you. They cannot give you legal advice. And so when you go before the judge to do the prove up on your agreement or whatever you have for the divorce, it can be way wrong. And the judge is probably sitting there like screaming inside because she knows what you're doing is terrible, but she can't tell you and she can't fix it. She has to accept the agreement the way that it is and just let you screw it up.
Right.
And then they don't have a choice, right? And so if you're thinking, oh, well, the judge will help me fix it if there's an issue. No, the judge is going to let you push it through just the way that you want and then let you pay thousands and thousands of dollars later to try to fix it if it can even be fixed.
Right. Right. And so, the core problem with the DIY divorce is, again, you don't know what you don't know, right? There are very complex legal concepts as it pertains to children and as it pertains to property, that we've studied really, really hard to learn, right? And we've practiced really, really long time to try to figure these things out. And so these DIY forms, they're not made to address those types of issues, right? Those complex issues. They're literally fill in the blank, and there's different, sections that you can click and different boxes that you can click. And so you don't know a lot of times what these words even mean, right? And Chat GPT is great, and I think a lot of people have begun to utilize Chat GPT, and it will help you, but it's not going to, number one, it's not legal advice, it's not an attorney. There's been questions that we've asked Chat GPT just as tests, and it comes back and the answer's completely wrong, right? And so you can't rely on those resources. That's why there are lawyers, right?
And we can always tell when we have a pro se party, a party without an attorney on the other side, when they filed something with ChatGPT.
Right.
You can read it like a book. It cites cases that are incorrect, right? Bad case law and things like that. So it does give bad advice. It's good to like get you a starting point to know what to look for, I guess, right? But to rely on it to walk you all the way through your divorce and what your rights are not, you know, terrible for that, right? That's why they have lawyers, and so we can never be replaced by AI.
That's right. And then so, some of the things that we've seen, we were just kind of talking about some different examples of things that we've seen with these DIY forms, right? And again, a lot of times it's after the fact. And what's really sad, we've had it happen a couple of times where we've had consultations and we tell, the party, hey, it's going to be X number of dollars for us to represent you in the divorce. And then they decide, okay, we're going to do these DIY forms. And then a year later, they come back and they say, hey, this is all screwed up now and I need your help. And it's like, now your price is twice as much, right? 3 times as much, because I don't know that I'm going to be able to fix this at this point, right? And so whenever we've had these people come in, these are kind of some of the things that we've seen. And some of them are addressable, right? And a lot of times as it pertains to children, we can fix some of the issues, most of the issues. With the property, that's when it gets a little bit more complicated and a little bit more difficult. But one of the things that we see is conservatorship failures, right? So normally you have like a joint managing, you have a sole managing, there's rights and duties that are supposed to be allocated to each party. In that particular section of these forms, there's a lot of things that you can click. Again, if you are not an attorney, you may not understand what your rights and duties are, what you're entitled to and what you're not entitled to. And so we've seen it happen where one parent was given all the rights and the other parent had no rights. And now they're coming in and they're saying, hey, she's trying to, put my kiddo in a mental hospital and I don't want my kiddo to go. Well, I'm sorry, but she has the exclusive right to make those decisions. And so at this point, you can't stop her unless we file something to intervene. And that's going to cost you a lot of money, right?
I've seen where multiple boxes are checked: the joint managing and sole managing and possessory. But you can't do that, right? But you don't know what these words mean. Most of the time when I'm talking to clients and I say conservatorship, they have no idea what that means. They call it custody or whatever, right? And so they just check the boxes because they think it sounds important, and it is, but you can only check some of them.
Right. One of the other thing that we'll see a lot of times is they'll click where it has to be, or check where it has to be joint, decision making power, and it's with an ex-spouse that they absolutely hate. That's completely unreasonable. And now everything that you do with your kiddo is by joint agreement, and the other side won't agree, and so now you can't do anything with your child. And so now we have a surgery that they really need to do, but the other parent won't agree. And you're rushing back into court to say, hey, judge, I need your help with this. And then you have this issue of, well, at one point you knew or you believed that this should all be done by agreement, and now you're trying to change it. Why are you trying to change it? And so you added an extra burden to yourself that, had you done it right the first time, we wouldn't have to deal with, right?
Yeah, or if you failed to check a primary or failed to designate a GO or accidentally designated the wrong primary because you didn't know what it meant, right? Now your burden's even heightened because you can't modify that on a temporary order unless the child's in danger, right? And you can't modify it all within the first year unless the child's in danger. Right. And so just failing to simply check one box can raise your burden enormously where sometimes we can't fix it. Right. Before the problem is created, right? It's just, yeah.
And so the other thing that we've seen is with visitation issues, right? So I've seen that so many times, like, dad will have visitation pursuant to Exhibit A. So I start flipping, right. Like, there's no Exhibit A. Like, what the hell? So I'm like, well, what have you been doing for the past year and a half? Well, basically, when she says I can see him, I'll go see him. And I'm like, well, no, like, you should have a schedule that's set out for you that is guaranteed that she can be held in contempt if you don't get to see him. But because they didn't attach Exhibit A, now you're screwed. Or they'll do something like, dad will have the children when mom is at work, right? And that's not an enforceable order, right? And so, mom's going to work, but she's not giving you the kids, and now you're pissed and you want to hold her in contempt. Well, we're going to have issues with that language.
Or as agreed upon. Yeah. They'll have position when they mutually agree.
Right.
You can't do that. It's terrible.
Right. And so, the thing is when we're drafting visitation schedules, we have to be very, very specific. There's specific language that's complicated, right? And the reason why we do that is because we want to hold the other party accountable, to allow you to have the visitation. And so we want to be able to place them in jail, hold them in contempt if they start to violate the order, right? When you're doing these DIY forms, a lot of times you're not incorporating that language because you don't know what you don't know, right?
And if that's the case, then your rights, your legal decision-making rights and stuff to your children, your possession and access rights to your children are worthless, right? If we can't enforce them to make sure that you have those rights, then they're not worth the paper they're written on.
Right. Well, another thing that we've seen, though, it's been really sad is, we get a call. My ex is moving to New York with my kids, and I don't want her to go. Like, she can't take my kids. She can't take my kids, and she's leaving tomorrow. She just told me. And we look at the order and we say, sir, you didn't click a geographic restriction. She can move wherever she wants to, and you can't stop her. Well, I want to file some paperwork now. I want to put a geographic restriction in now. Well, I'm sorry, but that's not the way the law works, right? We have a different burden, and you can't meet those elements. And so, unfortunately, she's going to be able to relocate. Well, I want to make her move back. I don't think that the judge is going to potentially make her move back. So like this, and those are those situations where sometimes there's no recourse, right? And he's like, well, I didn't know that I could even ask for that. I didn't know that that was even a thing. I understand, but it is, and you didn't do it, and now she can move, and you're gonna, lose your kids, and it sucks.
In addition to that, now all the other future custody cases are going to be in New York, so he's going to have to travel to New York to deal with all of his child stuff now.
Well, and then when she does that, there's typically no allocation for visitation and travel expenses and how he's going to get his children. And now he's paying full child support, but he's traveling to New York, once a month trying to get his kiddos. And so those types of issues, yes, we can address in a modification, but it's really, really sucks. And had he potentially hired an attorney in the beginning, the geographic restriction would have been imposed, and we wouldn't have to worry about any of that stuff, right? But that's why we strongly encourage you to not do the DIY divorce.
And you mentioned child support. That's another problem that comes up, right? Either people just leave it blank. Of course, put in the wrong number because they don't know how to calculate child support. Don't put a date on which it starts or which is due, which you talked about earlier about the enforcement, right? You can't hold them accountable for the child support if there's not a certain amount and certain dates that it's all due. And then also retroactive child support, right? Your ability, if they don't know, right, what they don't know, they have a right to go back and get past due child support. I don't even know if that's a checkbox on the pro se forms.
I don't know. I don't know if it is or if it isn't. But a lot of times we'll see these things. Well, yes, I put $200 on the paper because he would only sign it if I only put $200 on the paper. But he told me he was going to give me $1,000 a month, and he hasn't been doing that. Well, legally, we can only enforce the 200, and so there's no recourse for that. No.
I had one where he was gonna make the mortgage payment, but then she moved a boyfriend in, so he quit making the mortgage payment, right? And so now she was stuck with a very nominal child support amount, and we couldn't do anything about it.
Yeah, yeah. So, um, the other thing is a lot of times, and I think maybe the DIY forms have this in there. I don't really remember, but there's injunctions that a lot of times we can put in place to protect you and to protect the children. And so, things like a morality clause where no boyfriends or girlfriends will stay overnight, like no disparaging remarks in the presence of the children on social media. There's all sorts of little rules that we can put into place just to protect you guys and to make you feel more comfortable and protect your kiddos. Sometimes those DIY forms don't include all of that. And I think the way that it typically works is you have to pull those sections, right? There are different sections on the forms. And a lot of times what I'll hear is, well, my ex-wife just printed this and she gave it to me and I looked through it and I just signed it. So they're not even exercising due diligence to see what other things they could be asking for. They just sign it because they want to get it done, because they don't want to pay a lawyer. They want it to be done quickly and they don't want to fight. And then they realize their kiddos are moving now or they've waived rights, whatever.
And the injunction that you were talking about, those are kind of the standard ones that may or may not be included on some of the forms, but there's also very specific injunctions we can put in place to protect your children, right? We do them for like no corporal punishment, right? No leaving a certain person alone with the child you have concerns about, right? So there's all kinds of little specific injunctions that we can implement on your case to protect your children that are not on those forms, and you don't know to include them.
Right. Yeah. And the other thing is like miscellaneous items like activities and travel. We've had that happen where, kiddo is in what's the word, like academy baseball, right? And the fees are crazy and they have to travel. And mom's like the one who's in charge and it's costing her $1,000 a month and dad's not helping. And she's upset about that. And dad's like, hey, use your child support. If we had if we had an order and we knew that this was going to be an issue, then we could have incorporated those provisions to make sure that travel was addressed and cost was addressed, etc. So that's something else that those forms don't address.
And then international travel provisions, right? I don't think they address those either, but we can incorporate provisions to where if you're going to travel with it, or one parent's going to travel with the child internationally, they have to notify the other parent. There's like a form they have to fill out, right? Where they're going, when they're leaving, what their flight is, where they're staying when they get there, when they're coming back. And it also orders the other parent to comply with passport provisions and consent to travel, right? I don't know how many times I've been called when these forms are used and it's like, hey, we're going out of the country for vacation in 3 months. I need to get a passport. I'm like, we got to work quick, right? I don't know if I can get it done that quick. Get the petition filed and into court, and you get the passport processed in time. And so that's another provision, the international travel and passport provisions that we'll usually implement into our orders that are not on the pro se ones.
Okay. And again, a lot of times what happens when we're talking about, we're talking with our clients about these types of cases is it's just a natural conversation. And when we're having this natural conversation, they'll say something that is a concern. And I'm like, oh, well, there's a remedy to that, right? Like we have a way to address this. But they don't know until they're just saying like, this is how I feel. This is what I'm thinking about. And it's like, okay, not a problem, right? Or sometimes you can't do that. And this is why you can't do that, right? That's not going to be accepted by the court, etc. So again, you don't know what you don't know. That's why you hire an attorney. So next section is going to be property division.
Nightmares.
Nightmares. Property division nightmares was our title. And so these are the ones that I feel really bad about because a lot of times there's no takebacks on this stuff, right?
Can't file a modification, huh?
No. So first thing that we've seen is improper or incomplete asset listings, right? So a lot of times we'll see things like, wife keeps stuff in her possession, husband keeps stuff that's in his possession, and that's it, right? And they sign the divorce. Okay, so the next section that we need to talk about are the property division nightmares, right? And the reason why we call them nightmares is because um most of the time when it comes to property there are no takebacks, right? And once you sign this, once the judge signs it, it is very, very difficult to go back and try to figure some of these things out. Okay. So one of the things that we see is that like an asset that you guys own at the time of divorce is not listed. That there is potentially a remedy to, right? So we can file a petition for post divorce division, post dissolution division, or
Yes,
something like
post
that.
dissolution division. Yes.
Okay, so we could file that motion to say, hey, judge, we own this asset. It wasn't divided during the divorce. Now we need to divide it, right? And we actually, had a case like that where for some reason, they just didn't list the house, and the wife had been living in the house for like 10 years. And the husband got upset with her over some grandkids or something. And he said, I'm going to go and I want you to sell the house now. And she had been paying on it. And so it kind of got a little bit messy. But we were able to go in and get the divorce or get the house for her post divorce. And so that one, maybe you have a little bit of wiggle room depending on how that DIY form was filled out.
Sometimes you divide it and you don't know you're dividing it.
Right.
Sometimes you check each keep own bank accounts, retirement accounts, etc. And one of them has $300,000 in their 401k. That's not undivided property. That is divided property because you checked that really vague general box and you did not know what you were dividing. So with that, we can't go back and fix that.
And they'll say, I didn't know. Like, he didn't tell me that he had that money. If I had known, I would have never done this. Well, I know. That's why we don't use these forms. Right?
We say if you'd hired an attorney, you would have known and you would have done this.
Right. Right. And then sometimes you have, you're checking these forms and check, or writing something in saying this is, how I want things to happen. And they're not legally valid, right? Because it's not stated in the correct form, or maybe it's not something that is legal for you guys to do. Or maybe you think that it's a great idea in theory, but from a logistical standpoint, it's not going to be enforceable. And so, just it's a mess when it comes to those improper and incomplete asset listings. We had a case where I think they had maybe checks like each party keeps their own property or the property that's in their possession, and at the time that they signed they were both like living in a trailer. And so then the question became, well, who does the trailer belong to, right? We were both living there. And so it was technically divided, but it wasn't specifically stated. And so that was a fun thing that we had to go in and try to litigate and figure out. And again, I think that probably ended up costing more than what the divorce would have cost because they were in agreement with everything at the time. But post divorce, husband gets upset and now we have a fight. And so, what else, Floyd?
So I guess it's back to the things that they don't know, right? A lot of times people will come in and like a vehicle will be in their name and they don't think it's community property, which we talked about before. They may have had it before the divorce, right? Or they received it by gift or inheritance. And then it's actually their separate property. So it's just not even mentioned, or it's divided in with the community assets when it's not a community asset and they don't ever confirm it as their separate property.
Mm-hmm.
They don't know they have a claim for it as separate property, right? Because they don't know the separate property rules and laws and all that stuff that go with it. And so a lot of times we'll see a mix up with, community and separate property and being divided or not being divided or incorrectly listed.
Right. Well, and I've had that happen like during a consultation where they'll call and they'll say, well, we have an agreement on everything and I'm going to keep my house and it's worth, $100,000 and he's going to keep his retirement and it's worth $100,000. And I'm like, okay, cool. So did y'all buy the house during the marriage? And she's like, oh, no. I had my house before we got married. I got it from my divorce. Well, okay, so he can't touch that. That's yours. And so his 100,000 that he acquired during the marriage, that's what we have to split. This house is already yours. Don't worry about it. But had she done a DIY form, she would have missed out on $50,000, right? So
divorces are generally cheaper than $50,000.
yes. So separate property issues, you potentially have tracing issues to be able to run down those separate property claims. You have reimbursement claims. I don't know that any of those or the reimbursement claims are typically addressed in those DIY forms. I think we have a whole other video that explains
Yes.
reimbursement claims. But again, you don't know what you don't know, right? We talked about retirement accounts. We've talked about business interest, or we haven't talked about business interest, but businesses need to be divided in the divorce, and businesses typically have a value. And normally we do business valuations. And so even though the business may be, netting, I don't know, $100,000 a year, that business could be worth significantly more because there's CPAs that come in and look at assets and depreciation and all this stuff that we, have to rely on them to give us, and that you could be waiving a $500,000 asset without even actually recognizing it, right?
Yeah, I think the point of this is there's a bunch of legal theories that are not included in these pro se forms because of DIY forms, because that's not what they're meant for, right? Um, and so because they're not listed, you don't even know to look at it, right? Where if something, it'll flag us, right? If we say, well, like, oh, what about this? What about that? And so by simply not knowing these legal theories and including these, I guess, means of recovery, right? You're waiving thousands and thousands and thousands of dollars that far exceed what it would cost you just to hire an attorney, to make sure that your rights are protected and that your assets are protected.
Right. And I don't know, did we talk about, oh, here it comes right here. So,
We haven't talked about
we
it
haven't
yet.
talked about it yet.
Yeah.
So
Kind of.
one of the issues is judgment language that can't be enforced, right? And so sometimes you'll see in these DIY forms, like, husband's going to pay me $20,000. And like, that's the extent of it. And then they come to us a year later and they say, well, he was supposed to pay me the $20,000 and he never did that. So I want you to put him in jail. And it's sorry, it doesn't work that way, right? Like, there was very specific language that needed to be incorporated. You didn't do that. Now you're screwed. Now you get a piece of paper that says he owes you the $20,000 and we can try to recover it. Well, he doesn't have anything. He sold everything and his girlfriend ran off with it. Okay, well, now you're probably not going to get $20,000, right? So, a lot of times you don't have deadlines for exchanging of property or assets or funds or accounts. And so it makes the enforceability a problem.
Yeah, and that's one of the things that makes these forms so complicated. DIY divorces so complicated, and hold my beer moments and watch me destroy this, right? Because not only is there a lot of difficulty in getting the assets divided, the children, all the language correct, but then also, so you've done all this, now can I enforce it, right? And so you have to get it all correct, but also make sure that language is there to protect you and to ensure that what you're trying to accomplish, you can actually enforce and accomplish.
Right.
Um, you talked about houses, right? And you said you talked about the one where it was in both person's name, they both live there, right? In that case, right, if it were going to be divided, particularly if it's financed in both of their names, somebody's got to get it out of their name, right? Otherwise, that person can still be liable for it. Mm-hmm. And so there's specific language we put in for that, to refinance it by date certain, or sell it, and things like that, to make sure that you're protected down the road.
Right. Right. And so I've had that happen before where they did the DIY form and the husband was going to try to buy a new home, and he goes to apply for, the mortgage, and finds out that the wife had been late, like numerous times, on paying the mortgage, and I think was at some point behind for a significant amount of time on the mortgage, which severely impacted his credit. And because it was a DIY form, there was no deed of trust to secure assumption. There was no refinance or sell provision. There was no, if you're late, you have to sell provision. There was nothing like that. And so there was literally nothing that we could do at that point. And it prevented him from buying a home just because, he didn't want to hire an attorney to begin with to handle the divorce.
There could be, 15, 20 years left on that mortgage that he just had to suffer through.
Right. Right.
Terrible.
Right. Retirement and real estate mistakes. So, we, after the divorce, and I think people get frustrated with lawyers in general, but divorce
Not so much
lawyers
with me.
specifically. I think they get frustrated because it seems like things should be relatively simple, right? Like we're going to sell the house, or I'm going to give her the house, and that's it. But it's not that simple, because there's processes that have to be followed and things that we have to do in order to enforce it, in order to make sure it's legally binding. And everybody gets frustrated while we're doing it until things hit the fan, and all of a sudden you need to enforce that language, and then now all of a sudden we're really grateful for all the hard work and effort that the lawyer put into it, right? And so in this particular case, once a divorce is final, there's other documents that we have to do. And so there's a qualified domestic relations order, a special warranty deed, potentially a deed of trust, potentially an OLT deed, all sorts of things that we normally will draft to protect you. That if you're doing a DIY form, you don't even know probably exist.
Yeah, I love it when clients are like, well, there's nothing left to do. Judge granted my divorce, decree signed. But yes, but now we have to do all the stuff to make sure that what we said in the divorce and how we divided it can actually be done via quadro warranty deeds, power of attorneys, things like that. And so they do get frustrated with that process. Like, it's just ongoing and ongoing and ongoing. But if we don't do those things, you're not protected. And DIY forms, like you said, they don't know to do them.
Right.
And so they come to us and bring us unprotected assets, and we have to tell them, sorry,
Right.
good luck.
So we have this why amicable DIY divorces still fail, right? And so on the trailer example, where the trailer was awarded, or all property was awarded to each in their own possession, in that particular case, the husband had moved out of the trailer. Wife had been living there for years and years, and everything was going great until I think wife got engaged, or ex-wife now got engaged to her new fiance. And when was moving the fiance into the trailer, and when ex-husband found out about it, that's when he filed paperwork to sell the trailer and to kick her out of the trailer. And that's, so everything is amicable until it isn't, right? And that's when the enforceable language and making sure the decree is drafted is so important, because if she had done it right the first time, she could have said, piss off, this is my trailer and my fiance is moving in, there's nothing you can do about it. And in that particular case, we had to fight to make sure she was protected.
And that's one of the things you pay us for, is to foresee what you don't see coming, right? I don't know how many times I've had this conversation with a client where they're like, this isn't necessary. I'm like, it's not now. Right. I mean, we've probably seen what's going to happen 100 times. Right. And so one of them is like significant life changes, right? Like you talked about that case, for example, that case that you mentioned earlier where mom moved to New York, right? So dad in that case may have never anticipated mom. Mom gets a job offer in New York, and now all of a sudden she's relocated with the children in New York, and there's nothing dad can do about it. And so life changes like that will impact what everybody thought was just going to be fine.
Well, and I mean, I think, the key takeaway is everybody wants to do this DIY divorce because they think it's going to be cheaper. But there is always a cost associated with it, right? Either you're going to pay an attorney to handle it for you, or you're going to pay in time lost with your children, or you're going to pay in money that you should have been given, within the division. Or you're going to pay an attorney in the future to come back in and try to fix the screw up, right? So there's always going to be a cost associated with it. And so, like I was saying, so if you do a DIY divorce, there's going to be a cost that you're going to have to pay. And so we're going to spot things that you don't even know exist, which is going to be for your protection and the protection of your children. And if you have children and or property, a DIY divorce is almost always like 99.99999 probability that's going to be a mistake, right? So I just, and would encourage you, find an attorney that will help guide you.
Yeah, despite popular belief, we do more than just fill out forms.
Right, absolutely. So as we always say, do not construe this as legal advice, right? So this is for informational and educational purposes only. Our hope is that you will take some of this information, you will go and you will retain an attorney, because you're not going to do a DIY divorce, and you're going to listen to that attorney's advice and their guidance, because they'll know the judge, they'll know your situation, and they'll be able to guide you properly. So if, however, you find yourself in the DFW area, we do have offices in Lewisville and Flower Mound, in North Richland Hills, and in Dallas. In West Texas, we have offices in Midland and in Odessa. And so if ever you need guidance and you're in those locations, please feel free to reach out to us. We're here to help. And also make sure that you follow us on all social media platforms. So TikTok, Facebook, Instagram, so that you can make sure that you find other videos like this.